Thank you, everyone, and good afternoon, and welcome to our monthly Criminal Justice Reform Workshop Series. This month, we're featuring Professor Guha Krishnamurthi, who is currently an assistant professor at South Texas College School of Law in Houston, and will start as an associate professor at the University of Oklahoma College of Law this fall. Professor Krishnamurthi's research interests are in criminal law, criminal procedure, and jurisprudence. Before joining the South Texas faculty, he was a Clemenco Fellow at Harvard Law School. He also clerked for the Honorable Goodwin Liu of the California Supreme Court, the Honorable Andrea Wood of the U.S. District Court of the Northern District of Illinois, and the Honorable Diane P. Wood of the U.S. Court of Appeals for the Seventh Circuit. He practiced as a litigator at Irell and Manella LLP, Munger, Tolles and Olson LLP, where he specialized in general commercial litigation, white-collar crime, and antitrust. He attained his JD with high honors from UT School of Law and his BS with distinction in mathematics from the University of Michigan, and an MA in philosophy from the University of Texas. So please welcome Professor Guha Krishnamurthi, who will present his article, which has been selected for review and publication in the SMU Law Review, The Case for the Abolition of Criminal Confession.
Great. Well, thank you everyone for coming to my talk today. I'm very excited to speak with you. And thanks so much to the Deason Center for having me. So I contend we should completely abolish confession evidence from criminal proceedings. Principally, I argue that confession evidence, that is the I did it statement, is of little probative value. At the same time, it's extremely prejudicial and it creates a number of pathologies. I claim that we can see this through four modalities of legal reasoning. So there's an epistemic kind of theoretical argument, there's a practical empirical argument, a moral due process argument, and finally, we can look at the doctrine to see this. And then I contend we can look through the other solutions to the problem of confession evidence to see that abolition really works best. The main solutions I'm going to consider are imposing more restrictions on law enforcement, using expert evidence, and requiring more indicia of reliability. I think abolition is really better than all of these solutions. Okay, so as a preliminary matter, I'm going to define a confession, and you can see I've given some elements to this, as statements made by a defendant claiming that the defendant committed the crime or satisfied particular elements of the crime with the knowledge that the statement's going to be used in their prosecution. So importantly here, what I take to be the confession is going to exclude, say, corroborating information provided by the defendant. It is only the statement that the defendant actually committed the crime. So an example can help here. Imagine someone says they committed a murder, and the defendant says they committed the murder. They say, I did it. And then they identify where the bodies are buried. So the former point, that I did it, is the confession, where the latter is the corroborating evidence. And I'm going to be focused on the former here, okay? All right, so first to the theoretical argument. So I have a lot in this paper that explains why I think, what I think is the right construction of the beyond a reasonable doubt argument between conceiving of it as in terms of explanatory virtues or in terms of seeing it probabilistically. And I'm happy to talk about that in Q&A, but I think the point can be made more succinctly, and maybe the final version will do that. So essentially, if we inspect the reasons for why a criminal defendant would confess, realize that the confession's not going to tell us very much. It's primarily the defendant's rational calculus. So that's going to involve the chances of the defendant being convicted, the sentence they face, and maybe the terrible conditions of the interrogation and being in jeopardy, right? Being investigated, being put on trial. That's all, overwhelming. Those are the kinds of things that lead a defendant to confess. But an innocent person, right, is in the same position with respect to those reasons to confess. Consider an analogy, right, that might resonate with all of us thinking about illness in this pandemic time. So two people who show symptoms of the flu come in, and the doctor presents them with a tissue box and says, you know, if they take the tissue, they have the flu, and if not, they don't. All right, so this test doesn't really do much to tell us who has the flu. I think we can all agree about that. But at the same time, many people are going to take the tissue because they have the symptoms like a runny nose or a cough. And many of those people will actually have the flu because it's flu-like symptoms that actually brought them there in the first place. So the tissue box test, it may look good, right? It may have like a high level of picking out who has the flu, but we know it's not actually a truth adaptive test. It's not actually good. The test is actually parasitic on other evidence of the symptoms in this case. And I contend that confession evidence is the same thing, right? Confession evidence is parasitic on the other kinds of evidence that led the defendant to be there. All right, so that's roughly my claim about why it's not probative. Now, we can also see that it's extremely prejudicial, okay? And the Supreme Court has itself identified this in Arizona v. Fulminante. The Supreme Court tells us the confession is like no other evidence. It's the most probative and damaging evidence. And one of the reasons why is it comes from the purportedly most knowledgeable and unimpeachable source, right? The person themselves. And it has a profound impact on the jury, such that we could say that the jury just cannot put it out of its mind. My court, the court that I worked on, the California Supreme Court, sort of said this: the confession operates as a kind of evidentiary bombshell which shatters the defense. And then there's this maxim, confessio est regina probationem, confession is the queen of proof. So this is sort of the theory, which is that we have very non-probative evidence, but it's extremely prejudicial. All right, well, the practical evidence confirms these points in droves. And we can look at how the practical evidence of how confessions are actually extracted in interrogations. So the key steps in interrogation are shifting the defendant from confident to hopeless, and then eliciting that confession from the hopeless defendant. And this is all set out in the very influential Inbound Manual on police, confessions. So law enforcement uses various psychological techniques. They're going to isolate the defendant for some time. They will use continued strong accusations. They cut off and overwhelm the defendant's denials. They'll attack the defendant's alibi claims. They'll also make general claims of strong evidence, which may be true or false, right? Law enforcement might appeal to the defendant's demeanor to suggest that the defendant is guilty, and even if not, the judges and jurors are going to see it that way. They may also appeal to fabricated evidence during the interrogation, such as non-existent witnesses, false fingerprints, make-believe videotapes, fake polygraph results, and the like. And so, for any evidence that the law enforcement actually do have, they're going to exaggerate the amount and strength of the evidence. They also may make explicit or implicit inducements to the defendant. Law enforcement is just acutely mindful of the defendant's rational calculus that I set forth before, and they employ the methods that have very little to do with whether the defendant did it, but actually play upon that rational calculus. So now I want to talk about the empirical evidence, and to this I want to stress two studies. So there's this wonderful study by Brandon Garrett, and then there's this study by Appleby, Hassel, and Kasem. So first, Brandon Garrett's monumental study of the first 200 cases involving exoneration based on DNA evidence. So of these cases, the vast majority involved really serious crimes. So 141 involved rape, 44 involved rape murder, and 12 involved just murder. And the reason is that most of those cases are the kinds of cases that are going to involve DNA evidence. Now, of these 200 cases, 15.5 involved false confessions, and about 6.5% involved self-inculpatory remarks that were short of a confession. So we have about 22% of these involved convictions tainted with some kind of defendant self-inculpatory remark that was false because the defendants they didn't do it. Now, the very interesting thing about Garrett's study is that it involves a matching set. So he took some bare parameters for each of these cases. So the crime, the location, right, and the approximate date period. And for each of these, he found a matching case. So for each of the false confessions, he found a matching case. And those matching cases are presumably true convictions, right? We don't know exactly because we didn't do a full deep dive in them, but we have good reason to think that they're true convictions. The data from these matching cases is really revealing. About 20% of those cases involved confessions, so those are true confessions. Now, assuming those are true convictions, we have a very similar confession rate, about 20%, in false convictions and in true convictions. So I think this bolsters the contention that confession evidence is not really truth adaptive. It's parasitic on other evidence and really driven by the defendant's rational calculus. If you're in that hot seat, right, facing trial for a serious crime, maybe facing a very huge sentence, being sort of like, overwhelmed by law enforcement actions, you have a kind of certain likelihood to confess whether you did it or not. So the other study by Appleby, Hassel, and Kasson is further, confirms this potency of confession evidence. So this is a mock juror study where they took 140 or so college students. They separated them into groups, and they presented a summary of an experimental rape murder case. They were partitioned into 9 groups, which received either no confession or one of 8 written versions of a signed confession. And they differed on the amount of detail, whether there's a motive explanation, whether there's an apology. They all kind of differed on these bases. So in the no confession group, 30% of jurors voted to convict. Okay, so not that many. In the other 8 confession groups, 95% voted to convict, with little difference among them, right? Even the bare admission of guilt, that I did it, right, led to a 95% conviction rate. Didn't really matter if there was more detail or anything like that. So what do we take from this, right, from this empirical evidence? Confessions are not truth adaptive, right? Like people in the hot seat have a sort of likelihood to confess, but they're extremely potent, right? So they're not probative, but they're really prejudicial. All right, so now we can get to the moral due process concerns. All right, so on the screen, I'm just going to post the language from the 1984 Convention Against Torture. And so just to be clear, I'm not making the claim that police interrogation is torture. I'm not disavowing that claim, but I'm not going to make that claim here. But what I want to identify is that Kant has these certain indicia of law enforcement conduct that raise rather serious moral concern, right? Severe pain or suffering, whether physical or mental, right? That's intentionally inflicted on a person for such purposes of obtaining from them information or, that's detrimental to their case or confession. And so, other philosophically minded definitions of torture include the assault on the defenseless, the creation of pain, fear, or uncertainty, creating self-betrayal in a person, saturation of the target's consciousness with panic. So there's a lot of these kinds of definitions focusing on mental anguish, hopelessness, isolation. And as I suggested before, from these law enforcement manuals talking about how to pursue interrogation, it's pretty clear that law enforcement raises some of these main concerns. They are, playing on a defendant's hopelessness, right? They're trying to create that situation. They're isolating them. They're pressing them with false evidence, etc. And so it has some of the same kind of indicia of moral concern that Cat tells us to be wary of. So why is this important? So here's why. I've given us reason to think that confession evidence is not good. It's not truth adaptive, and it's prejudicial. So one might ask, well, what's so bad about evidence that's not very good? Let the adversarial process figure that out, right? Well, I've given us reason to think that's not feasible because of the prejudicial nature of that. But even beyond that, there's another issue, which is that if extracting the evidence raises moral and due process concerns, then we really shouldn't do it in the absence of it being probative. That's another reason that we should really disavow it. Okay, so finally, I want to talk about the doctrine. And so I'll just put all of these on there just so I don't run out of time. But our criminal procedure is filled with doctrines to address these problems of interrogation and confession. And I just think they don't do enough work. So specifically, the Miranda prophylactic rules can be waived by the defendant and require clear exercise by the defendant. Now, this is a real problem because these defendants who are likely to waive Miranda, right, are exactly the ones, the ones that are most susceptible to interrogation are exactly the ones that can be lured into waiving their rights. So that offers them no protection, right? If you're the kind of person who is susceptible to these interrogation practices, you're very likely to be the kind of person who's susceptible to law enforcement saying, waive your rights and then confess, right? That's kind of a very little add-on there. All right, so what about the due process voluntariness protections? Well, so early in the court's jurisprudence, including the case Bram, the court actually had, it had a very progressive jurisprudence with respect to confessions. They said, if you were tempted at all, then if you, by promise of light treatment or whatever, then then the confession is not voluntary and not admissible. But then in Colorado v. Connolly, the court imposed the requirement that there must be some triggering, law enforcement conduct. And the bar there is quite high. And so basically, this is not good enough because my argument is that the pressures to confess are endemic to the criminal justice system, that they aren't necessarily triggered by something that the law enforcement does, but the fact of being investigated in general, right? And the sentences that one might face, the convictions rates, etc. All of these lead defendants to confess, even if law enforcement's on their best behavior. Finally, I want to talk about the evidentiary limitations, and these are generally toothless. It's very easy to meet the corroboration requirements for a confession, right? If somebody says, I confess to murdering that person, if that person is dead, right, that might be enough to corroborate that, corroborate that confession. That's very little, right? So these are sort of toothless and they don't do enough work. The key problem here is that the doctrines fail to understand this key point, that innocent criminal defendants have strong reasons to falsely confess even without any intervening offensive conduct by law enforcement or prosecution, but rather to these pressures inherent in the criminal justice system. Without addressing the crux of that matter, no doctrinal solution is going to work. All right, so I want to just very quickly talk about solutions because I know we're running up on time, but we should always talk about solutions. So some of these solutions are more restrictions on law enforcement conduct, expert evidence, requiring more indicia of reliability, and then my favorite, abolition. All right, so more restrictions, kind of pointed already to that. I don't think that's going to work because the problems are endemic to the criminal justice system. All right, what about expert evidence? What if we would just tell jurors, right? We allow experts to testify to jurors that, they pull up Saul Kassan and Brandon Garrett on the stand, right? And they would tell jurors, confession evidence is really not that great, right? What about that? Well, in principle, that might work. And mock juror studies have shown that this has some potential. But I think the mock juror studies actually sort of obfuscate a fact about a practice, about legal practice here, which is that if any of you know about how expert evidence goes, both sides get experts, right? And mock juror studies usually just include one expert, but both sides will get experts, and both sides' experts are very compelling. I myself, in my antitrust and patent days, was able to bring in experts that could at least muddy the waters, right? And what ends up happening is you have what is called the battle of the experts. All of this goes over the jury's head, right? And it doesn't really inform them. You have one expert saying that confession evidence is great, one saying that it's not very probative. It's highly technical. It's very difficult for the jury to comprehend all of this, and it turns out to be a wash. So this is my main concern with expert evidence. Okay. Finally, of these other solutions requiring more indicia of reliability. We could do that, but I think that actually strengthens my argument. We could say, look, if we're going to admit a confession, then we're going to have to ensure that they provide corroborating evidence, like a high degree of corroborating evidence, etc. My claim there is, well, then why not just use the corroborating evidence? Right? We know from these other juror studies that the I did it is just an evidentiary bombshell. It just does so much work. So why should we include that? If you have all this indicia of reliability, just present that, right? And that's good enough, right? So essentially, I think the requirement of requiring more indicia of reliability proves the case, right? That really we don't need the confession. We should abolish them. So what might this do? So this could have some dramatic impacts on plea bargaining and interrogation. And I'll leave for questions if people are interested in that. I'm happy to talk about it more. But I do want to make one point that this proposal is not just a trial proposal. It's also a proposal for plea bargains. We can have plea bargains, but they can't depend on the defendant saying that they did it. They have to be corroborated with evidence that would withstand the beyond a reasonable doubt standard at trial if they were to go to trial. And we need judges to really police this, right? And so that's kind of requisite for this proposal to do good work. Okay, so with that, I'll end. Thanks so much for listening to that, and happy to take your questions and comments.
Thank you so much for that presentation. So it's my job to both moderate, and I also get to exercise the moderator's privilege. So typically the way these work is people either send their questions to me. Sometimes students don't quite know how they want to phrase it, and so they'll email it to me or chat it to me. I like your thank you slide. But I'm going to exercise the moderator's privilege and begin by asking you, well, first of all, let me just say, I wish that I thought that this was realistic, but part of what scares me about this, right, is the enormous hurdle that you describe in your article. But I want to hone in on this idea that what you brought up at the end, not just trials, because it seems to me that to be a meaningful solution, it has to deal with the bulk of what happens, and the bulk of what happens is pleas. And I'm curious, how do you imagine that that would be a viable option, given the way the courts have said they understand the purpose of plea bargaining. And here I'm thinking of that the Ninth Circuit case called Ruiz, right, where the Supreme Court says, yeah, plea bargaining is the way we do things, and we're not even going to require the disclosure. I think it's exculpatory evidence, or it's impeachment there. We're not going to require the disclosure of impeachment evidence prior to a trial, prior to a plea, because that would slow the trains. And we're not going to be willing to require the U.S. Attorney's Office, God forbid, to slow the trains. How does this logistically, something like this, work in the mass volume of plea bargaining cases?
Yeah, so I do think that this is this may be a dramatic change to plea bargaining, right? So, at the first level, I think judges, when they are, looking at what corroborates the plea, it requires judges to put out of their mind that the defendant is saying that they did it, right? And so some judge has to do that, whether it's the sort of plea accepting judge or the judge on appeal or somebody's got to be able to do this. And if we don't have that kind of buy-in, then I have to admit that the project is not going to get off the ground, right? If the judge sort of says, even sort of the recesses of their mind, well, they said they did it, right? If they're sort of adopting the kind of probative information of the confession, then this isn't going to work. So I have to get that kind of judge buy-in for this to be meaningful. But if I can get that buy-in, right, then I think the judge has to look and say whether that body of evidence, excluding the confession, but whether that body of evidence there would be enough to stand, beyond a reasonable doubt, would support the conviction beyond a reasonable doubt.
But if you're a prosecutor, and if you think about kind of the day-to-day piece of it, right? They're always looking to get their young assistants trials for a second. Think about that, right? Why in the world would you bother pleading anything? Right? Which might not be a bad solution, right? I mean, this could be a break the system approach, but why would you plead anything if you had to go and pull together all the evidence that would be required to corroborate a confession or a plea?
Sure. So one thing is, I think that there are so many criminal cases that even if they decide not to plead some, right, and they want to, have people cut their teeth on some of them, they're going to plead out a bunch. Now, for this, I might cite something. So one of my firms did a kind of, they had a program where attorneys at the firm could serve in the city attorney's office for 3 or 4 months and prosecute, DUI cases and several, some felonies, etc. And so, they wanted to make sure that everybody got some case, right? Some case that goes to trial. It's not just plea work. But there were so many that even there, a lot of the ones that people handled were pleas. The thing is, you'd get maybe a couple of trials, maybe 3 or so, but you would still handle probably 10, 15 that were on plea. So I think that even if it increased the number of trials, which I don't think is a bad thing, right? I'm okay with that.
I agree, right.
Even if it did, I still think we prosecute so many people that they would still have to proceed through, they may just not prosecute them, which is okay too, right? That's okay.
Right. I mean, this is certainly right. I think, if I understand what you're saying, then there would be a certain number of cases that prosecutors would be forced to abandon, right? Because they cannot corroborate, right? That cuts down on volume. There'd be a certain number of cases where they have to do what's essentially almost like a preliminary hearing, right? The only with a Bard standard rather than a probable cause standard.
Yep.
Right. And I guess the question then becomes, is there enough in it for them to offer a deal? And if not, at least in places where there are guidelines, does your proposal end up hurting defendants more than it helps them? I'm imagining a world in which people are forced to trial because there is no evidence corroborating other than their confession, or at least not enough to get over the BRD standard.
I mean, it's unclear to me. I mean, I would think so certainly there will be some defendant. There will be one defendant who may have been able to plead out and will have to go to trial. I think you'd have to ask, right, defendants, but some of them may just end up getting get their cases abandoned, right? Because they can't actually meaningfully plead because they don't have sufficient evidence. And oops, oh, sorry, yeah, sure. Okay, somebody there for me. Thanks so much. As the defendants as a whole, I think would benefit, but I think, yeah, there may be some defendants that that end up going to trial when they would have rather pleaded out. Now, one thing is, right, it may change how we sentence too, because if they say, look, I would have been willing to confess, right, but we just don't allow that evidence, they may get the benefit of, in our current system, an acceptance of responsibility thing, which we might have to expand in order to, sort of make it fair for them.
That would certainly help, right, in a guideline system, but it won't help you in a mandatory minimum system, right? I'm imagining the case where you get the bump down. So we have a couple of questions in the chat. I will leave this in the weeds conversation for another time, but let me, good.
Can I say one thing? So one thing just might help about my agenda to put everything in perspective. So coming down the pike, I have a project on a right to a bench trial, questioning mandatory minimums, questioning recidivist premiums. So I think of, so many of the points that you made about, maybe we've got to change these other things, I'm utterly sympathetic to. I think that we have to, so.
Well, thank you. And I have more questions at this. We have questions from the callers. We've got, so Robert, I'm so happy to have you here. So Robert Dinaj, who just turned his camera on, comes to this from a, excuse me, a unique perspective, having been a chaplain at the Bureau of Prisons for many, 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 many years. And he's asking about all the people who told him that they were required to plead for just the reasons you're discussing, right? Acceptance, and sometimes the bump down, right? From a higher mandatory minimum to a lower. And he said, how do you navigate the fact that people who can't afford representation are maybe in a situation where they don't trust their lawyers? They've been told that getting a plea is the only way to avoid the mandatory minimum. What do you tell those people? Does that mean, Robert, am I getting your question right?
Yeah, you did. Yeah.
Okay.
Yeah, so at least one thing is that because what I'm excluding are the sort of I did it statements, and I'm allowing in the corroborating information, right? If one actually, if a defendant actually committed the crime, right, they may be able to present corroborating information that would sustain a conviction beyond a reasonable doubt, even in the plea stage, right? Now, one problem with this, they can be, subject to the same pressures, right? All the same things I've complained about before, that's true. But we would have less a risk of false convictions because whatever they end up presenting, would have to corroborate that they committed the crime. So there's still a way perhaps for guilty defendants to plea and support what I hope would be a true conviction. Now, there will be some bridge cases where there may be a couple of people, somebody knows something that could implicate them and implicate someone else, etc. But that might be one thing there. Now, I wouldn't counsel them to do that. I just wanted to suggest that that's a possibility. But it's a Hobson's choice, exactly. I think that's exactly right. And so how should a defendant handle that Hobson's choice is extremely difficult. And I don't want to pretend I have answers to that.
So I have two questions that have popped up, I think, just to me. One is this a thought experiment, or do you have a real implementation plan? And I think it's a fair question.
Yeah, so I think that this is not just a thought experiment in my mind, but it is a multi-step thing. So the first thing I think in the ways to implement this are the kind of thing that Illinois and some other states have just adopted, which is you can't lie to juveniles, okay? Now, I don't see why that's specific to juveniles. I'm on the board of the ARC, which is an organization devoted to people with intellectual and developmental disabilities. And one of the things that I saw in this research was that many of the people who were susceptible to false confessions and therefore false convictions were those who had some mental incapacities, right? And they're not just minors, right? They're adults too. So one thing is, I think that, we should expand the kind of, these kind of budding laws that say don't lie to people in interrogations. We expand that. The next step is probably expert evidence, right? Allowing expert evidence on confessions and their non-probative and extremely prejudicial thing. And if we get there, we might be able to move to the kind of sort of 403, Rule 403 stuff that I was talking about before, that kind of bans sort of categories of evidence that we think are just prejudicial and not probative. So I think that would be the multi-step plan on how to get there. But, maybe that's a dream.
So thank you for that. I have another student question, and then I see Kate Weisbert has one as well. Student is asking, and this is one Ashley, you could have asked this yourself. You got it exactly right. If confessions can't be used and the corroborating evidence was only found because of the confession, isn't that fruit of the poisonous tree? And what do you plan to do about it?
Right. So this is not a rule that suggests that, I think that interrogation can still proceed. Interrogation is not a constitutional violation. Obtaining a confession is not a constitutional violation, according to my proposal, right? So you can still get the, law enforcement prosecution can still have the confession, and that can actually serve a really good use in ensuring that they don't prosecute other people, right? It can help them build a theory of the case that's actually true. So that's fine. So as a result, using a corroborating evidence wouldn't be fruit of the poisonous tree, because it's not, obtaining the confession is not a criminal constitutional violation. Rather, it's simply barring a kind of evidence in the trial itself. So in an interrogation, right, you might be able to obtain past crimes evidence, right? Rule 403, you can obtain all this other kind of evidence. You don't get to use it in trial. It wasn't a constitutional violation to obtain that evidence. That's kind of the thing that I have in mind.
So you'd keep a threshold about voluntariness, but once it's voluntary, there would be no fruit of the poisonous tree. Is that what?
I think that's basically right, and so, yeah, I think that's right.
Okay, cool. Kate, you had a question.
Yeah. I'm happy to, I didn't know what the proper process was, but this is so great. It's nice to see everyone, and this was a great presentation. It's such a great, challenging thought experiment too. I think it forces us to ask really important questions. I guess my question is just, what do we do with the role that confessions play outside of a trial and outside of plea bargaining? So I'm thinking about sentencing, or in the context of when I was in practice, my clients were often sent to treatment programs, where part of the treatment was making admissions about what they had done. Restorative justice requires making admissions. So what do we do with the role of confessions in those settings? Yeah,
so my proposal is limited to the guilt stage, at least at this point. I thought about it when I wasn't. So the thing that concerns me most is the lack of probative value and the way that it could lead to false convictions. But once we have a true conviction, or something that we have a lot more confidence in, I have no problem with somebody then confessing for an acceptance of responsibility thing, or or just to help victims, right, in their striving for understanding justice and everything. I have no problem with that. I have no problem with the criminal justice system making room for that. Now, I have to say, I separately have, and this is one of the other sort of things I have a budding project on, I separately have a concern about acceptance of responsibility and that being requisite for a downward departure. I have a problem with that. So this project doesn't sort of directly address that, but if that's kind of where you also may have some skepticism, I am with you. I'm sympathetic to that.
Kenitra, you're up. And by the way, the reason we do it is a lot of the students don't want to ask their questions because they're feeling anxious about it. So we've discovered that we do better with student questions if they come to me.
Sure.
So nobody has any performance anxiety about getting it wrong, but everyone's welcome to jump in anytime they want. I just filter the students so they feel a little more comfortable.
Wonderful.
Kenitra.
So it's a thought / maybe there's a question in here when I get it out. But there's a way where there's a significant part of your paper that's been discussing how we overvalue in some places the criminal confession. But I contend that a way to probably bolster the argument is that we actually don't value that a confession in the post-conviction work. And I know we're talking about the front end of a trial phase, but it's really, really hard. Like the argument here is, yes, innocent people confess. And when those innocent people confess, and we know they confess under some coercion or things like that, when the real perpetrator confesses, it's almost impossible for that real confession to be given any type of credence in the post-conviction phase of that legal trial or that legal process. So it's a bolster. So I think there's somewhere in there where you can use, if we're having trouble conceptualizing why confessions don't matter, is that we already don't give it credence. This sounds really, really bad. We don't give it the credence that we ought to give it when people confess after a conviction, after a wrongful conviction. I mean, no, Pam, I'm simplifying a complex issue, but there's an argument to be made that there is already a model, which we talk about reform, right? Proving actual innocence is ridiculously difficult in our current system. I don't know if we should use that as the bolster for this one, but it is a thought. Yeah, it's problematic, and I'm making it a complex issue really small. It's a thought when you're thinking about it, is how we treat confessions on that end of it.
I love this point. I think it's so correct. I mean, I think this is wonderful, and it's so funny, right? That like when another person confesses to a crime for what the defendant has been convicted of, that prosecutors then have such skepticism about that, right? They would say, oh, you're only doing it to help them, you have this other reason, etc. But why would they not use those same reasons, right? The first confession in the first place, right? Oh, you might be trying
sometimes they get it during the trial phase. So I mean, that's why our Michael Morton rule has been expanded to the Richard Mouse rule. Like, it's because they have it, they just don't introduce it. But it's it's something to think about. But it's also problematic because we're talking about a place where we're also talking about reform used to bolster an argument about abolishing.
Can I piggyback on this? Because I think it's a brilliant point, Kenitra. And I think actually I would take it a step farther and say, isn't it deeply problematic to undermine confessions when in fact that if we improved the extent to which we take those seriously? I'm thinking about that the Chicago case that ended up on 60 Minutes, the guy who Andrew Morton, defendant confesses to his lawyers that he's the real killer, but won't let the lawyers disclose. The lawyers get an affidavit and they put it in a lockbox, and he says, you can disclose after I die. He dies, they bring it out, and there's already somebody working on trying to exonerate the person who's been convicted, and it's a whole ethics thing. But actually, it's not an ethics thing. The lesson is that that's not an ethics violation. But in any event, that's a great illustration of what Kenitra is talking about. Isn't there a universe in which we want some confessions like that one, where the guy says, on my deathbed, after I'm gone, you can disclose it, to be weighted heavily? I mean, if I'm channeling the Innocence Project people, and generally I'm not, like I'm a Guilty Project person, but if I'm channeling the Innocence Project people, your rule is really terrifying.
Well, so the confession cannot be used against that own, the defendant themselves. But if they confess, right, it could be used in somebody else's trial. Actually, that might sort of encourage a kind of confession, right? Like maybe encourage false confessions that are then used offensively by defendants in their own cases.
I mean, and that's sort of the argument, right? When you argue about 3.8 in the ethics rules, and you argue about whether what the obligation is of prosecutors to take seriously someone else's confession, one of the arguments is, you know, if we start taking those seriously and we have to run those down and we treat them as having strong evidentiary value, everyone and their brother who's already convicted and doing an OWOP, right, doing life in prison without parole, will just confess out of the goodness of their hearts because they want to exonerate other people, right? Whether or not they did it, you're going to get as many false confessions.
Right. So a couple of things here. One thing is there is a sort of very technical part of the paper early on where I talk about how perjury is kind of exempted because the act of making the false statement itself is the crime. So people who are falsely confessing to crimes to law enforcement officials or to prosecutors or under oath or whatever may still be susceptible to perjury. Now, if you think that there's, if you think that we can effectively criminalize and charge and, pursue perjury, that may be a deterrent to that kind of ruse. But the other thing is, again, like, I don't really have a problem with prosecutors having to, if somebody else confesses, I don't really have a problem with prosecutors having to ensure, right, that that person didn't do it. And that may take more work, but I think that's just part and parcel of the beyond a reasonable doubt standard. So that is not, that's, I sometimes say it's not a bullet I have to bite, but a pie I want to eat,
Yeah, like that. That's very helpful. Kenitra, I think that was a great point.
It's cutting both ways, and I don't like when things do that. It both bolsters and limits the argument. It's cutting both ways, but I'm sitting on it for a little bit because we don't. It sounds like what it's also triggering here is that a confession is an automatic. If we ought to think about it, if it's not just an abolition, it's an automatic trigger for an investigation. Like it automatically triggers the investigation. It's a stopping point. You confess, we're done. Instead of it being, okay, you're arguing, it's just an evidentiary tool, not an evidentiary stop.
I like that a lot. I like that way of putting it. Yes.
So we have Robert, I'm going to just let you say it because you'll say it better than I will.
Yeah, good afternoon. The old adage, confession is good for the soul. Again, from my vantage point, being a chaplain and a spiritual caregiver, I found that it serves a cathartic and therapeutic purpose for both the defendant and the victims, especially when I was doing some ministry on our death row. The victims looked forward to some degree to some type of confession. And so I found it to be very helpful, but strictly coming from a clinical pastoral standpoint, nothing legal, evidentiary, but that's kind of like my take on it. But that's a good probative question though, Kenitra.
Sorry. Yeah, certainly. And I think that's right. But I hope that my proposal doesn't cut off the ability for any of that, right? So if people want to, if defendants post guilt, right, want to confess, that's fine, right? There can be a colloquy for that at the sentencing. They may be able to personally, contact the victims and express that, right? That we can make room for that. I'm really thinking about its sort of role in guilt, in determining guilt. And so there's the only place I want to exclude it. And I should maybe say, all criminal proceedings dealing with, guilt determinations, because I think it's completely, available, right? We should make room for it for all the reasons that you say in post-guilt and external to the trial, sort of mechanisms, right? If a defendant wants to, through their attorney, contact the victim separately, even during the guilt stage proceedings or whatever, I have no problem with anything like that. We'd have to work out the logistics, but I think that's fine.
So can I double back to something in the paper where you spoke about plea bargaining and judges listening to pleas, and you mentioned it in your talk, the idea that maybe there are judges who hear, oh, somebody confessed, therefore they must have done it. And I'm going to say to you, Not only are there maybe, but I think most of our judges say if someone got arrested, they must have done it. You know, except for those judges who were cops, and they tend to, in my experience, tend to say if someone got arrested, they must have done something, if not what they're actually charged with. So I'm skeptical, I think, about whether at some point the root of the problem for you isn't going to be changing the hearts and minds of decision makers who are judges, not juries, right? In the sense that one, juries are your minority, but two, you can do an awful lot of sculpting and shaping and a lot of good lawyering with jurors. You cannot budge a judge who's made up their mind from the second you walked into the courtroom. It doesn't happen. I mean, at least, you know, not in my experience in state court, and maybe more likely in federal court because I see fewer cases, and I think often have perhaps thought more deeply about some of these issues because they don't have so many cases. What do you do about that? I mean, judges are going to be judges. That's how they get elected.
So that's right. And so I'll say a couple of things about this. So one is that I think we should diversify the bench. So we get more, you know, public defenders, then, you know, maybe things can change. Now with judicial elections, right, some of that is going to be difficult, especially in states like Texas and Oklahoma, right? Like my home states in some sense, you know, tough on crime judges can win elections and they often run on that platform. That is a big problem. And that may be a huge impediment to getting the kind of buy-in I need for implementation of this. I want to admit that. But one thing that's interesting in my bench trial project that I'm working on now is that I've seen the conviction rates in bench trials are actually a lot lower in at least some jurisdictions, in some data sets that we have, that they are lower than jury trials, which I was surprised by. I was happy to see it, but I was surprised by. So maybe there are, you know, like if you think about like why that might be the case, sometimes it's because judges hold lawyers, prosecutors to a high standard. Now they might not be doing that. These are not high felony cases, just to be clear. So they may be doing that in DUIs, which are serious, but perhaps, you know, you might think of them as lower on the totem pole at least. So judges say, well, you know, I was a prosecutor, you need to do better than this, or something of that sort. So I'm at least, you know, I guess I just don't know yet what I think about how judges operate, but I'm sensitive to these concerns. And I think that, you know, that might be a problem in implementing this, you know, judge selection may be a problem. I think so.
So I'm going to just moderator's privilege again. Let me just say that one point that might be worth thinking about in your bench trial piece. I don't know where you're getting your data from, but I think it depends a lot on whether these are places where you need both parties to consent to the bench trial or just one. And I'm thinking about the Louisiana example. So, you know, and if you're familiar with it, stop me. I won't.
No, I'd love to hear it.
You know
I think I am, but I would love to hear about it.
That's always the right answer. I know it, but I want to hear you anyway. What I'm thinking about is the fact that bench trials used to be used when defense lawyers and judges agreed that the case was nonsense or agreed that the government was out of line. And there was a tacit understanding that you were going to have a bench trial and the judge was going to acquit. And I mean, I've actually had a judge say to me, Pam, have a bench trial. And I'm like, but I want to have a bench trial. And finally, Pam, I'm going to acquit. I'm like, okay, we'll have a bench trial. When that became clear to prosecutors, the law changed, and you now had to have both parties agree. And I think there was like, you had to announce the request for a bench trial 90 days in advance or something like that, something long ago. And my suspicion is that would have significantly altered the way in which the bench trial data looks, right? When it's one party, when it's a unilateral right to a bench trial, which it was under Louisiana law until not long after Katrina, versus both parties have to agree. Is that your sense of the bench trial data?
So at least one of the jurisdictions is a dual jurisdiction requirement. I can't remember which one it is, but at least one of the jurisdictions where this isn't my data set, it's somebody else that gave me it. I believe one of those jurisdictions it requires prosecutor consent, which is one of the reasons it was surprising. I don't remember, there were 3 jurisdictions. I don't remember how many of them were, but I do remember that at least one was, that I checked it against my list and I was surprised by that. So, yeah, I think that's sort of interesting. I also think there's a federal data set which does require prosecutor consent, and that one too had better bench trial results for acquittals.
Interesting. I wonder on the federal side though, how many of those are people who were forced to trial because the chief of their division said you got to go. I mean, I'm thinking about you know, the Thornburg years and you know, apparently the Sessions years as well, and the Barr years, and whether, you know, because there's this other piece of me that always wonders about the performative trial where the brass says it's got to go, and the courtroom working group is like, yeah, okay, fine, we'll handle this ourselves. I've dragged you far enough off. I'm sorry, I didn't.
No, this is wonderful. This is super helpful for this and the other projects, so I really appreciate it.
Let me then ask a different question that's come up about confessions and kind of their value. Why start with confessions? You mentioned ID testimony, and presumably IDs have the same issues in terms of the police investigation and that being a stopping point. I think I'm using Kanitra's phrase here rather than a starting point. And they strike at least me as a maybe a smaller mountain to climb, in the sense that our heuristic about what a confession means, I think, is stronger at the moment than our belief in eyewitness testimony. We've been successful, I think, at chipping away at it a little bit. Maybe I'm wrong, but why start with confessions?
So this is probably just more like a kind of story of how this project came to be. It really just came out of a sort of a theoretical point, which was that it was sort of like the theoretical section of the paper where I was sort of like, well, so I am partial to an understanding of the beyond a reasonable doubt standard, which is something of this sort. Something is beyond a reasonable doubt if there's no other plausible explanation for the evidence of guilt. Okay, that's something of what I like. I studied with Larry Loudon, who's like sort of like this, and so that was kind of one of the things. So this was from law school, and I remember thinking, well, suppose we have a person who confesses, but the evidence, without the confession is not very good. Does the confession get us to no other explanation would be plausible? And my suggestion was no. Right. So it started as actually just a small project. I thought, oh, I'm only going to do like that point in a kind of very short paper. And I presented it, when I was doing the Clemenco to my colleagues, and they were like, you can blow this out. You can, there's empirical evidence for this. You can do more on this. And so that's kind of how this generated. But I will say that like the ID testimony stuff is fascinating. And I think that many of the same theoretical tools can be used to challenge that, and I hope to do it in the future. Oh, I think
I'm on mute. Sorry, I said that would be terrific. That would be really great. So usually at this point in our program, and we sort of jumped ahead here, but we usually offer our presenters an opportunity to ask what help, if any, they'd like from the group, or what thoughts, if any, they'd like from the group about where they are with this project or anything else they're working on. And as I said, we sort of jumped the gun on that one. But we always like to try and make sure this is as valuable for you as it is for us. So what is it that's on your list, or do you have questions that folks here might be able to answer?
Yeah, so I think that there were sort of like a couple of things I had about the paper. Particularly, I was wondering, I think a kind of soft spot of the paper is sort of the moral due process arguments, and I wanted to get a sense if people found that convincing. Do they think that it required more attention? I'm running up on way too much of a word limit. I got to cut. So, you know, was that worthwhile to people? That's kind of one question that I had. Another question I think is just, you know, does the project really occur to people as utterly fanciful, right? Or does it seem like something that, you know, that were people's reflections afterwards, like, yeah, maybe we should, like, I think that could be a good thing, you know, that's kind of like that gut check sort of sense. But those are like the two things that really came to mind. And I mean, I had so many other questions, but so many of them were answered and, you know, probed by your great questions. So I just really, really appreciate this.
So I'm going to take the second one first, and then I'll see what Kenitra has to say, or Robert, anybody else. I think we lost Kate. I'll tell you that my gut was thought experiment, and then by the end, I was like, oh well, maybe he's serious. I think I would put it in the front, and I was trying to think of an analogy for something kind of that bold. You know, and I would have said Miranda, except Miranda was sort of an accident, right? I mean, Miranda was not a deliberate decision, right? It's kind of a, and then I thought, well, you know, the closest analogy that I could think of to this kind of a proposal is what Jeff Fisher did, right? With the Crawford line of cases. Yeah. I mean, that was kind of that is the most, I think even more than Booker fan, it's the most radical adjustment to our understanding of the way that evidence functions in a courtroom or does not function, right? Of an exclusion of evidence based on constitutional principles, right? Now, slightly different than what you're doing, right? I mean, because you're not going for, you know, Jeff went hard and heavy on you know, kind of leaning on who he had on the bench, I think, in part. But, you know, I think you do yourself a disservice in the paper if you want it to be taken as a concrete proposal, not saying up front that this is a long-term vision, you'd have to take steps to get there, but this is something that can and should be done. Because I think otherwise, if you're an old dog like me, I'm so deeply skeptical, I'm deeply skeptical of solutions that require people to be better. Yeah. I tend to believe more in solutions that are kind of, yeah. Anyway, let me stop there. Kenitra, I'm going to bounce to you.
Okay, so I think that first question, I kind of understood it, but I have so what I really heard there was that there's a length problem, and there's a good portion of your paper where I'm like, that's the math major in play. There's a bunch of,
yeah, that's true.
There's a definite need for discussing data first. There's a definite need for discussing data, how these decisions are made in these long form articles or in these articles that law students are looking at, that professionals are looking at. We need to learn how to read it, see it, do it. But if you're looking for places to cut it down, I think that's where it is, and not necessarily on that moral due process argument, because it's a big point. I think what we're seeing in legal scholarship and procedural work is that a lot of people are criticizing the fact that the courts keep limiting due process, like moral and procedural due process rights. And so where we're bolstering why that's a problem, that's actually probably something necessary in the paper. I wouldn't take the data out. There's a lot of time spent on explaining how to look at it. And so maybe the math teacher in you can pull some of that and make your word problem. On the second question, which pulls at me more than what's happening with the length of the paper here, is that actually, so the abolition of the criminal confession is a big deal, right? But the conversation around criminal legal reform is abolition. Some of the things that we're dealing with, that we're jostling with now, is even advocating for abolition. Not that it's just big, but is it elitist? Who wants it all? But then you take this one thing where we're talking about abolishing a criminal confession, and I think what it does is it contextualizes how big the talk of abolishing the entire legal system as we think about it is, right? If thinking about the criminal confession and abolishment is this big for us in the system, or those of us who are talking about it, this also then makes that conversation about why abolishing the criminal legal system is a conversation that's hard to have slash, I mean, I think it contextualizes it. I think when we talk about it, people are seeing, yes, absolutely, you know, rethinking policing, rethinking all of these other things. But then you talk about one evidentiary tool. You talk about abolishing the criminal confession, and we can see the reverberations all the way through the criminal, but through the criminal legal system, but also the criminal courts and punishment process. We can more easily conceptualize that. So there's, along with Pam's suggestion about, you know, putting upfront, this is what you're doing.
Yep.
I think literally acknowledging that talking about this as a step-by-step process can also give us some insight into why conversations about abolishing entire systems and not just a tool is also a tall order. I think what this did for me was contextualize what we're talking about in a broader abolition. It's why it's a longer conversation, because we're talking about a tool, and we can see how effective. I mean,
yeah, I think that may be right. I think a hook, maybe. I mean, I'm just piggybacking on that,
especially for your research agenda.
I think the conversation we were just having, where you said, look, if a collateral consequence is we have fewer cases, right? Great. If a collateral consequence is that we're so busy trying to try the important cases that we have to let the small cases go, we can't run as many cases through the plea mill. Great. I think being explicit about that does add a lot. I hadn't even thought about that, but I think that's right.
Excellent. Okay, that's great. I really appreciate that. That's like,
I mean, what this is resonating for me, what this is reminding me of is the year after Miranda, right? If you go back and you read the newspapers from that year afterwards, and you know the sky was falling in, you know, they may have been right that had anyone taken Miranda seriously, the sky would have fallen in. And what you're now doing is really the next step. You're saying, okay, you didn't take Miranda seriously, so let's just eliminate the confession altogether. And if you're right about that, and they were right that the sky was going to fall, then you really do have significant consequences. And I think in that instance, you're really underselling your piece by letting people focus too much on the trial piece, right? And not building that out.
great. Yeah,
that's
that's wonderful. Yeah.
So we are just about out of time. We try and wrap these up just a couple of minutes before the 75 we give, so that people can log off and get into their next log meeting, which is apparently the way we live now. Although hopefully not for too much longer. Next time we'll be able to get you here, since you're local-ish, right?
Yes.
So I want to thank you so much for joining us, and I want to thank the students for great questions. And I know Kate had to jump off, and a couple of our other folks had to leave, but thank you so much for doing this. This is really, it's a fun paper.
Thanks so much. Thanks for having me. This was fantastic. I'm super excited, and super excited to attend future ones too.
Well, great. We'll look forward to having you.